Hello there! Today, we will introduce a civil case concerning intellectual property in Malaysia. The plaintiff is Honda, a well-known vehicle manufacturer, and the defendant is a local company called DNC Asiatic Holdings. The case began in 2014 and was judged by the Kuala Lumpur High Court in 2018. Honda, the plaintiff, brought a claim against the defendant under the Copyright Act 1987. It is hoped that it will stop producing products that infringe intellectual property rights and seek financial compensation. However, the defendant countersued Honda for unlawful economic interference with the 2010 Competition Act. There are 16 that were debated on the trials for a decade. There were 6 things that were debated on the trials for this case. The trials talk about whether there was any infringement, whether copyright subsisted, the ownership of copyright, whether plaintiff owns copyright in the works, whether the defendant's motorcycle was a reproduction, and whether there was a legitimate competition. Without further ado, let's jump into the case. Infringement. The EX5 graphic contained copyright, and it was a work protected by a copyright in Malaysia as of October 11, 1990. The plaintiff had put forth considerable effort in making the drawings as defined by Section 73A of the Act, and the drawing had been reduced to material form as required by Section 73B. The Honda EX5 drawing was eligible for copyright protection under Section 71C of the Act since it was within the scope of the Act definition of artistic work. Copyright subsisted. The drawing was admissible under Section 73A1 of the Evidence Act 1950 because the plaintiff met all of the requirements of that section. Mr. Koizumi's non-attendance at the trial was covered by the proviso to Article 73A1 because he was beyond the seas and it was not reasonably practicable to obtain this appearance. Ownership of copyright. There was no other motorcycles that were similar to the EX5, and the defendant had only informed comparisons based on similarities in a specific portion of the motorcycle. It would be clearly incorrect to break down the EX5 into component parts and compare each section separately from the rest of the design aspects. The defendant had failed to establish that Mr. Koizumi plagiarized the EX5 drawing from other sources. Plaintiff owns copyright in the works. The EX5 motorcycle's 3-dimensional form was also eligible for copyright protection. The 3-dimensional depiction did not have to be an exact replica of the 2-dimensional representations. It was enough that there was proof that the 3-dimensional representation were based on 2-dimensional drawings. The plaintiff owned copyright in the EX5 drawing as well as the 3-dimensional models created from it, as well as the complete chain of modification and works associated with the EX5 works creation process. The plaintiff had demonstrated prima facie evidence that the plaintiff owned the copyright. Defendant's motorcycle was a reproduction. There was no evidence to back up the defendant's claim that their Demak Spark was created independently. The defendant had failed to meet their burden of proof that they did not plagiarize the EX5 works. In the emblem, opening on the side cover, ornamental rubber piece with 16 ridges, rare combination lamp, and instrumental panel, there were evidence of close similarities between the plaintiff's EX5 and the defendant's Demak Spark. The Demak Spark was a near exact replica of the EX5 motorcycle. Legitimate competition. The defendant's counterclaim was devoid of merit. The defendants presented no evidence to support their claims. The plaintiff did not infringe on the defendant's trade, commercial, or economic interest in any way. There could not be a legitimate competition because the defendants had infringed on the plaintiff's copyright. In a conclusion, Appeals 2 was rejected with cost of 20,000 ringgit Malaysia levied on the appellants. The Court of Appeal upheld the High Court's findings on the question of sustenance and ownership of copyright in the claimed works. The High Court reasons that, under the concept of national treatment, as a signatory of Berne Convention is required to provide the same copyright protection to nationals of the Berne nations, in this case Japan. The plaintiff also presented evidence to support the claim to ownership of the claimed works copyright. As a result, Appeal 2376 on the question of sustenance and ownership is also rejected, with the appellants facing 20,000 ringgit Malaysia in costs. Allocated fees apply to all charges. Those infringement-related challenge would be dismissed. We should also take note that allocated fees apply to all charges. Those infringement-related appeals would have to be heard. The date will be communicated to the parties in a timely manner. We hope you understand the case well. This video is created by students of Media Law MLL 2013 from the Faculty of Applied Communication FAC, for the purpose of video assignments set by the Faculty of Management, Multimedia University, Cyberjaya, Malaysia. This video is for the purpose of the assignment and well as a study and non-profit research only. Appropriate acknowledgement to the materials that do not belong to the video owners have been publicly made. If you are a copyright or a trademark owner of any of the material used in the video, and you object to such inclusion on any grounds, including copyright infringement, please contact us and we will take your material down. We are using the material pursuant to the doctrine of fair use. Thank you.